This course is Business Law 526 offered by CALMAT for 2011, and this is the homework for Chapter 33, Question 14, Green versus Hocking. My name is Darren Tay, and the homework is assigned by Professor Samuel Tong. Okay, the topic is a consumer make a purchase on a credit cards. So the card issuer refused to accept the charge. Then an attorney sued the consumer for the amount due. But in the complaint filed in the lawsuit, the attorney wrongly stated the interest was owed at 18% annually. This statement was later corrected by an amendment of the complaint to 5%. So basically the case against the consumer was ultimately settled, but the consumer then sued the attorney for penalty under the Fair Debt Collections Practice Act, FDCPA. So claiming that the overstatement of the interest due in the original complaint was a violation of the act. So the attorney defended on the ground that the act did not apply. So the question is, did it? So let's see. Defendant Hocking, this is the fact, who filed a collection suit on behalf of a client. So on November 1986, so the plaintiff Green used a credit card to purchase an electronic keyboard from Highland Appliances, but the Visa refused to accept the charge. Then the Highland assigned the debt to the Lee Corporation. In June 1991, Hocking serving as the attorney for Lee Corporation, filed a complaint in the state court against Green. So after they settled the dispute, Green sued filed a suit in the federal court that against Hocking that violated FDCPA by misstating the total amount. Okay, so the complaint, as you can see, alleged that violated number 1 and number 2 here. The next is my client Hocking. The plaintiff Green cited in support of the position that my client is a debt collector, between the meaning of the FDCPA is wholly opposite. Okay, basically Hocking acted as a legal counsel for a client rather than just performing traditional debt collection services. Okay, here the conclusion is, of course, the Green motion for judgment is denied. So I affirmed the judgment of the district court. Okay, the court find that an attorney who regularly filed legal actions for purpose of collecting debts on behalf of a client is not a debt collector, within the meaning of the FDCPA. Okay, so Green simply alleged that Hocking violated the FDCPA when he filed the complaints. Hocking litigation's activity were exempt from the FDCPA provision. Okay, so that's why I find Hocking's first argument persuasive. Next slide. In this slide here, I continue the conclusion here. The point is underscored by an attorney advertisement presented to the Consumer Affairs Subcommittee that stated, "Your member attorney is exempt from the requirements of the FDCPA of 1978. You are therefore protected against judgment on counter by your debtor based on unfair collection practices." Okay. So this case should be dismissed, as there is no good reason for it to remain on the court's docket. Thank you.